So we all know that there is new technology coming on the scene all of the time. We've heard of drones, we've heard of surveillance cameras, but there are other technologies that maybe we've heard less about, things like stingrays and automatic license plate readers. So here at the ACLU, we really think that it's important to have transparency in this subject. It's important to have a public conversation about whether these are appropriate technologies to be used and if they're being used in an appropriate fashion. And that brings us to our panel here today. We would like to see some standardized regulation put in place to regulate some of these technologies, but first we think it's important that everyone understand what the technology is and what it's capable of. And that's why we have invited Senator Goolsby and Nathan Wessler to come and speak with us today. So I'm going to introduce both of them, and then I'm going to just turn it right over to Nate. So Nathan Wessler is a staff attorney for the National ACLU Speech Privacy and Technology Project, where he focuses on litigation and advocacy around surveillance and privacy issues, including cell phone location tracking and warrantless use of surveillance technology. Today, he's going to brief us on the expanding use of several technologies, including stingrays and automatic license plate readers. Senator Goolsby, as most of you probably know, was elected to represent New Hanover County for 2 terms here in the General Assembly. As a senator, Thom Goolsby worked tirelessly as a defender of the Fourth Amendment right to privacy, as well as a variety of other issues, including human trafficking, several criminal justice reforms, and government transparency. As mentioned, I think I mentioned this earlier, Senator Goolsby was a primary sponsor of a bill that we had to try and limit location tracking through cell phones. And he also has a thriving law practice in Wilmington, where he practices criminal defense and personal injury law. And he's going to talk to us today about why he was willing to sponsor legislation in this area, and also why he thinks it's important that there be statewide regulation. So with that, I'm going to turn it over to Nate to get us started.
Thanks very much, Sarah, and thanks to all of you. There are many benefits to living in this increasingly technology-dependent and digital world that we're in. Electronic communications technologies, from email to text messages to social media, abundant cloud storage, and cheap and small computing devices make all of our lives easier in a lot of ways and change the way that we interact with each other and that we do our work. But these technologies can also have really serious privacy implications. The cell phone that's in my pocket isn't just a communications device. It can also be a powerful tracking device that the government can use to know my whereabouts. The emails stored by Google or the contents of my smartphone are a useful record to me. They can also be an incredibly detailed log of everyone I talk to and everything I do that the government may want to access. And as we go about our daily lives, there's really no way to avoid leaving what's essentially a trail of digital breadcrumbs that lead back to this incredibly sensitive picture of our lives. A central challenge of this digital age that we're in is really figuring out a way to make sure that there are reasonable and effective limits on government and law enforcement access to these kinds of very sensitive records and these large volumes of data. That's partly where the Fourth Amendment comes in. The Fourth Amendment has always required police to go to a judge, demonstrate probable cause, and get a warrant before accessing sensitive information and conducting a search. Now, unfortunately, as the government has gained new powers through technology and through data to learn things about our lives, the laws just haven't kept up. Congress, for example, is just mired in inaction, not only in this area, in others, as you know, but the federal statute that governs access, for example, to our cell phone location records, or even to the contents of our emails, and allows access to both of those without a warrant, was passed back in 1986 and has not been meaningfully updated since. Now, in 1986, there were about 1,000 cell towers in the entire United States. Cell phones, some people may remember, were about the size of bricks. Basically, nobody used them. Nobody was using email, really. And yet, this old law is still on the books at the federal level. And Congress really has some inertia. So it's falling to state legislatures across the country to update the laws and make sure that there are reasonable and effective limits on the kinds of private information about us that law enforcement can collect. So one of those areas, one of those types of information is electronic location tracking. knowing where somebody is and where they go over time can reveal some of the most sensitive details of our lives, where we go to the doctor or the psychologist, whether we sleep at home or somewhere else at night, who our friends and associates are. It can reveal whether on the way home from work we stop off at a liquor store or an AA meeting, whether we go to a fertility clinic or an NRA rally, and so many other sensitive parts of our lives. And our cell phones are powerful tracking devices that can reveal that information. Now there are two basic ways that law enforcement can get location information through our cell phones. One is through a request to the service provider, Sprint or AT&T or T-Mobile, and the other is by using their own powerful surveillance technology called a cell site simulator or a stingray. And I want to talk about both. So every cell phone service provider, every time any of us makes or receives a phone call, or sends or receives a text message, or increasingly just makes a data connection with a smartphone to check email or social media, the cell phone service provider is logging and retaining a record of which cell tower the phone was located at the start and end of each call or at the moment of that text message, and the direction out from that cell tower that the phone was in. It's called the sector of the tower. Now, as more people use cell phones and people with smartphones use more data on those cell phones, the companies are having to erect more and more towers, which means they get closer together, which means the space between them gets smaller, which means that the ability to locate somebody gets more and more precise all the time. And these companies are retaining this information about where we were as we used our phones for long periods of time. AT&T, for example, is keeping those records on a 5-year rolling basis. That's a lot of data about us. Just to illustrate one example of how much data these companies are keeping and therefore how much law enforcement can access. There's a case I've been working on that's now in the federal Fourth Circuit Court of Appeals out of Maryland, this case is, where police got 7 months of historical location data about a man without getting a warrant from a judge. They didn't demonstrate probable cause. Those records revealed over 29,000 individual location points for this man. It averaged out to about 134 per day over that 7-month period. And those records, they show when he slept at home on nights and when he slept elsewhere. They even showed when he was likely at the OBGYN office with his pregnant wife during that period. Some sensitive stuff. And it is the kind of information that police should have to get a warrant to obtain. Now, police can also get real-time cell phone location information from providers after a request from law enforcement, and they can do what we call a silent ping to the phone and get very precise information by triangulating which towers the phone is bouncing off of, and can let law enforcement track somebody with GPS-level accuracy moment to moment as they travel around. Police are doing this all across the country, including here in North Carolina, without getting warrants, and they're doing it a lot. We know, for example, that just in the first 6 months of 2014, AT&T received over 30,000 separate requests for this kind of location data from law enforcement, and the requests are increasing every month. The second way police can do this kind of location tracking of a person's cell phone is with their own technology. As I mentioned, it's called a cell site simulator, or more commonly known as a stingray. These devices mimic cell phone towers. They mimic an AT&T or a Sprint tower, and they send out a signal that tricks or really forces every phone in the vicinity to report back its unique identifying electronic serial number, and by virtue of the direction of that transmission and the strength of it, also allows police to learn very precisely the location of that phone. And this is all surreptitious. No person using their cell phone would have a good way to tell that police were tracking them with one of these devices. Now, there are a couple features of these stingray devices that raise particular privacy concerns beyond just learning our location and our movements. One is that they send signals through the walls of private homes and offices and other spaces that the Fourth Amendment to the Constitution has always given special protection to, and can very precisely learn the location of phones inside. And if you know where a phone is, you probably know where a person is, since we keep them with us almost all the time. And second, and maybe more troubling, even when police are trying to just track the location of one particular suspect, there's no way to configure this technology to avoid also sweeping in information about every other bystander's phone in the area who's using the network that's being mimicked. So you have what looks a whole lot like the kind of dragnet search that the framers of the Fourth Amendment were so concerned about a couple hundred years ago. There's been tremendous secrecy surrounding police use of this technology here in North Carolina and around the country, which has made it hard for judges to update the law to require a warrant for these. But we do know some information. We know, for example, that at least a half a dozen federal law enforcement agencies have bought them. We know at least 47 state and local agencies across the country, it's across 19 states and the District of Columbia, have bought their own. And that's almost certainly an undercount, both because there's a lot of secrecy and because a lot of agencies don't buy their own, but they borrow them from the federal government or from state police or from neighboring jurisdictions. Here in North Carolina, we know that police departments in Raleigh, in Durham, in Charlotte-Mecklenburg, and Wilmington have purchased their own. And as a result of some fantastic reporting by Fred Clayson Kelly at the Charlotte Observer, we know that in Charlotte, police have used these devices up to 500 times in recent years without getting warrants from judges. When they went to judges, they were getting orders on a much lower relevance standard, not close to the probable cause you need for a warrant, and were not informing judges of what they actually wanted to do, or describing stingrays or any of the privacy implications from using them. We've seen similar patterns around the country, in Tallahassee, Tacoma, Washington, Baltimore, and elsewhere. It's a widespread problem, and one that legislatures can address by requiring warrants. To that end, we've seen states across the country, red states, blue states, purple states, in the north and the south, the west and the east, passing legislation requiring a warrant for all the kinds of cell phone location information, from the carrier or using stingrays. In states as diverse as Colorado, Maine, Minnesota, Montana, and Utah. There's another set of states that have so far required a warrant just for the real-time tracking, not for the historical records, and hopefully we'll get around to the historical records. That's states like Virginia, Maryland, Illinois, Indiana. I'll just note that it's, I think, vital to address both kinds of records, the historical ones and the real-time. So those historical records, they really give police a power that in our entire history they have never had before. It's really a time machine that lets police go back in time and see where I've been over the course of days and weeks and months when they decide to later on in time. It's a powerful thing to be able to do and one that a warrant should be required for. So similar concerns are raised by another kind of technology that Sarah mentioned, automated license plate readers. These are cameras that take pictures of the license plate of every car as it drives by. They can be mounted on stationary objects like the side of a building or a light pole, or they can be put on the back of a police car to face out into traffic. And they log which license plate it was and where and when it was seen. Now there are some uses that are less controversial. If police are just looking to match to lists of stolen vehicles or wanted fugitives and then are deleting the other data, that's less worrisome. But what we've seen in a lot of places is retention of huge databases of this information for many months or often many years at a time, which creates an amazingly detailed record of essentially where everybody is driving all the time and where they're going once you have enough of these cameras set up. So we've seen, for example, that the Los Angeles Police Department is a database with at least 250 million of these plate records stored. In Maryland, in just a one-year period in 2012, there are 80 million of these records stored. Here in North Carolina, we know that as of a couple years ago, at least, the Washington Police Department was gathering 20,000 of these plate reads per month with no limit on the retention period. In High Point, we know that in a one-year period ending in the middle of 2012, there were over 70,000 of these records stored. That's a lot of data. The federal government is also getting in on this game. We know that the Drug Enforcement Administration has been setting up a nationwide network and is also feeding in local data and just has hundreds of millions of these records stored. So what to do? States are starting to step in, and I hope North Carolina will too. States like New Hampshire and Maine and Tennessee and Utah and others have set really strict retention limits on how long law enforcement can hang on to that data. And by doing that, have been able to hopefully avoid some of the worst potentials for abuse, to sort through people's movements over time. So I'll just close by saying that the experience of states and local agencies around the country that have adopted warrant requirements and adopted retention limitations for this data has shown us that police can do their job, they can do it effectively, they can investigate crime, and they can protect public safety by abiding by the kinds of regulations that the Fourth Amendment has always required, for example, a search for a search of a house. In this digital world, we just need to make sure that those old, time-tested rules apply equally to the new kinds of searches. Thank you.
Thank you, Nate. I'm Thom Goolsby. I had the pleasure of serving here in the General Assembly for the last 4 years and retired to go back to my 5- and 7-year-old and my wife in Wilmington and spend some time with them. This is a hard job, and I salute all the legislators that are here and all the people that dedicate themselves to the state in the very low-paying job of $13,900 a year, which hardly pays probably, many of your bills. But I really came up here as a criminal defense attorney, somebody who for years had been in the courts of North Carolina and the federal courts across the country, trying out cases. And as we started seeing these technologies that Sarah and Nate have talked about come of age and started realizing the extent to which these were being used, many of them used for a number of years. When you start talking about license plate readers, when I lived in the UK back in the early 90s, and the IRA was blowing up buildings. I arrived in London the day that the IRA tried to blow up Margaret Thatcher. I was at a party a block away when they set a bomb off at the Carlton Club. That was my welcome to Britain for the summer. And what was interesting is they immediately had started, right after that, license plate scanners. The Metropolitan Police would scan all the cars every night in the city of Westminster to try to find potential terrorist vehicles. That was back in the early 90s. When that technology first started being used. Now we're in the year 2015. We have these license plate scanners now that are not an emerging technology. They've been here for years and years. They're used all the time. The same that when I became aware, thanks to the work of the ACLU and a lot of our press out here, of the use of the Stingray devices, I became extremely concerned. I mean, here we have a device that fakes a cell phone tower to take information that we think is private to us, that I would think the cell phone tower owners would be rather perturbed about, and the cell companies, where the government comes in and buys a machine and is able to warrantlessly access all of your location information. And the potential is anything else they want. Now, I understand from the people that I've talked with about Stingray and all, it does not gather other information other than your location. That's what I'm told. I've seen pictures of the devices, never seen one. Can you imagine, particularly for our legislators here, if WRAL and the News and Observer decided they wanted a Stingray, and they were going to put all of your location information in that Stingray and just follow you around all the time, just to see where you were going and what you were doing? You would be outraged, and you should be. Well, I'm just as outraged to think that without warrants, the government can go and do these things. Now, you might say, well, wait a minute, Tom. These are the good guys. We're talking about the police. We're talking about criminals, and I understand that. And I'm all for putting criminals in jail after they've properly been arrested and properly been tried and all the evidence has come in that is legal, and they've either had a jury trial or a bench trial and they've been properly convicted. I believe in our Constitution. What I'm concerned about is when we have issues like Stingrays being used where there is no Fourth Amendment protection. So what's the answer? Am I against Stingrays? I don't think anybody on the panel is. What we're against is against using that technology and violating the Fourth Amendment. If you want to use the Stingray, fine. I'm all for it. And I've talked to our law enforcement officers. It's great. When you've got a guy, you've got a warrant for his arrest or he's fled, and you can find out where he is and get him. He's at his girlfriend's apartment in downtown Wilmington. I'm all for police being able to go in and get the bad guy. But you know what? You do it the right way. You get a search warrant. You don't violate the Fourth Amendment, and you go in and you get the bad guy. But to think that you can just buy a technology from a company or borrow it from the federal government and then be able to use it and violate all of our Fourth Amendments and say, oh, well, it's not really a violation because the law doesn't address this. Well, the law hasn't caught up, as Nate said, with the technology. But I can tell you, think about it. Somebody is able to find out where you are violate your privacy rights and arrest you with the technology that gives them all that data without ever having to go through the proper legal channels is just wrong. And what we have to do in North Carolina is pass appropriate laws to just say, look, you're going to use this technology and any other emerging technology that allows you to locate people, just do it the right way. Just do it the right way. I mean, I'm in court every day. I was in a trial this last week, a long jury trial. And I watched every morning as the judge was getting ready to come into the courtroom, officers show up, tell her about the search warrant they needed to conduct or whatever else, and the judge would listen to it, read it, sign off on it, and it was done. We have magistrates and judges available all the time to do just those kinds of things. There is nothing here that's different than anything else. It's just a different technology that we have to get in our heads requires the Fourth Amendment to not violate our rights. Because we all have rights. And when you play by the rules, the nice thing is you don't end up with a police state. You end up with the kind of country that we want to live in, where our rights are protected and the bad guys go to jail because they were legally arrested, legally prosecuted, legally convicted, and lawfully sentenced. That's what we want. Now, just to touch on briefly the tag technology, the tag scanners, the tag recorders. Another great technology that allows us to find bad guys. We got terrorists driving around, we can identify tags wonderfully. We've got tag readers and can locate them, that's great. Again, a new technology that's emerging, that is not emerging, that is here, that we still don't have a handle on, I think, at the state level and the federal level mentally about how to deal with this. And as Nate said, we simply need reasonable limitations on the data collection and how long it's kept to keep from violating people's rights. Who gets to use it, who gets to see it, how we actually use it. These are both thoughtful conversations that our legislators need to have. They need to be talked about, vetted in committees, and then passed to protect all of our Fourth Amendment rights. And I look forward to watching this as it plays through. I'd hope that we'd make a little more progress this last year. We did get the issue put forward. And again, around here, it just takes some time, usually, for things to make their way through. Bad laws get pushed through very quickly. Thoughtful laws and the kind that we need take a little bit of time to bake in the oven. And I'm hopeful that as we go through this long session, these issues will continue to be on the front burner and they'll get addressed. Thank you.
Okay, well, I would encourage anyone who has questions to flag down Mike or Chris. But in the meantime, I will sort of back up a little bit and talk about what some of the things that Senator Goolsby and I and others in the legislature have worked on already, and that we're going to be pushing again this year and hope to see movement on. You know, the ACLU of North Carolina has been working on this issue for a long time, and over the course of the last few years, we did several public records requests, often in conjunction with our national office, to get more information about this. And based on that information, we had legislation introduced. So in 2013, we worked to have legislation to limit the use of the tag readers. That was introduced in the Senate, Senate Bill 623, automatic license plate readers. And, you know, it allows the use of the technology. What we always like to say is that this is another technology like any other that might be incredibly useful, but it also might be a little bit dangerous. So we need to have good regulation on it so it doesn't get abused. So the automatic license plate reader bill that we had introduced did not prohibit the use of this technology. That was never our goal. Essentially, we said, go ahead and use it for the reasonable law enforcement purposes that it's intended, right? So this would be things like what was mentioned already, is running it against other databases to make sure a vehicle hasn't been stolen, not involved in any crime, as well as enforcing things like possibly parking tickets or even collecting electronic tolls. So, but what the bill would have done is say, as prohibit the use for things beyond that list, right? We're going to give you a list of things that you can use the automatic license plate reader for, and we're going to prohibit you from using it outside of that scope unless you go get a warrant. So even other uses might be okay, but they need to be brought to court and have a judge, a neutral third party, look at it and make sure it's okay. The other thing we would have done is prohibit the sharing of the data amongst government agencies or with the federal government without a warrant. And we would have required that the data be deleted every 10 days. So that's the standard that we would like to see in place, an automatic purging every 10 days of all of this data. Again, unless law enforcement goes and gets a warrant to keep the data longer. So probably not sounding like outlandish ideas here. All of this sort of relates back to pretty old concepts that we all value, concepts that are found in the Fourth Amendment. The other thing that we've done through public records request is find out a lot more about this location information and how local agencies have been getting information from cell phone carriers. And we actually just put out a report. I think it just got released yesterday. It looks like this, and there are copies over there, and I would encourage anyone who's interested to go and grab it, because one of the things it does is outline which jurisdictions have which technology. So we have our first question, and I'm going to hopefully be able to read this. So it says, what is the status of counter technologies that counter the surveillance technologies? So I'm going to direct that one to Nate, I think.
Sure, thanks. There are, for some of these technologies, there are some things that people can do to try to protect their privacy. For many of them, there's nothing they can do. So, for example, with stingrays, there is now software that some independent developers are putting together to try to be able to let someone with a smartphone detect when there's a stingray in the area. I don't think this technology is working very well yet. There's nothing, though, that can prevent police from using a stingray to locate somebody short of turning off the phone. Now, importantly, for all the forms of location tracking, even when somebody turns off the location privacy or the location tracking setting on a smartphone, right, so that will stop, say, Google Maps or the Apple Map function or any other third-party app from gathering location, but has no effect on the phone company's ability to locate and track that phone, and no effect on police's ability to use a stingray. So there's really very little people can do there. Automated license plate reader technology, similarly, there's short of taking the license plate off of your car, which then of course puts you in violation of state law, there's nothing to be done. There are ways to protect privacy for some of the other technologies we have. People can encrypt the contents of their smartphone or their computer so that they hold the password for it, and then police can get a warrant and try to break that encryption or try to get the password back from the person. So there are some privacy protective things like that, but for many of these there's just no golden bullet solution.
Okay, and then we have a second question, and that is, essentially, we've been emphasizing abuses by law enforcement, but this person wants to know, what about abuses by commercial, political, or other parties? And I think that's a really good question. And one thing, I'll just talk briefly about one of our experiences that we had here in North Carolina. Back in 2013, we introduced a bill to regulate the use of drones. So these are unmanned aerial vehicles or unmanned aerial systems. And we worked with a great group of bipartisan bill sponsors in the House. And unfortunately, that bill didn't move, but it did generate a lot of discussion, and eventually another bill that we were less thrilled about did pass as part of the budget in 2014. But the discussion that brought up was a lot around, people seem to be way more nervous, interestingly, about their nosy neighbor or their ex-girlfriend or whatever flying a drone behind them and following them everywhere they go than they were really about government uses of drones. And so it generated a lot of discussion. But one of the things that we realized as we were working on that is there are actually a lot of laws that might already address a lot of the concerns that people have about their nosy neighbor, or not every situation will be addressed, but oftentimes you'll have peeping Tom laws, or you'll have other laws that address some of those issues. And so while there might be new laws needed in some of these areas, one of the things that we really encouraged policymakers to do was take some time and evaluate the laws on the books before you get into those private uses. Because oftentimes, as in the case of drones, There may also be some First Amendment rights that get impacted. Things like artistic uses of drones to make videos or take photographs. There might also be some First Amendment issues with the use of drones by the press. And you want to make sure you're not impacting those in a negative way when you pass new laws. We do know that, like in the case with drones and in the case of these technologies we're talking about today, that the laws that were on the books were not getting at government uses. So we felt like it was safe to move forward with those government regulations and trying to make sure that people's rights weren't being abused in the meantime while we learn more about the technology and figure out what's going on. We didn't want to wait for a court to figure that out over the next 5 years. But with the private uses, we thought that maybe some time was going to be needed to figure out exactly how to fit all these laws together. So I'll let Nate and Senator Goolsby.
Yeah, I mean, I would just add, taking stingrays as an example, it's currently illegal for any private person to buy or attempt to buy one of these devices, and the manufacturers in the U.S. Aren't allowed to sell them to non-governmental buyers. They're also very expensive, by and large. People can get them from international sellers over the internet. It's hard to do. Now, for law enforcement, they're also very expensive for law enforcement, except for state and local agencies, truly they're very cheap because a lot of them are able to buy them either with federal grant money from the Department of Justice or the Department of Homeland Security, essentially free money, or they're using asset forfeiture funds, which have become very controversial recently because of the sort of profit motive that it gives some police departments to seize people's assets without trial or conviction. And so, that's a type of surveillance technology where private uses would be really troublesome, and we may well see some popping up, but it's really law enforcement that's using them, and law enforcement that, at this point in time at least, needs the most regulation, I think.
As Sarah was talking, I was thinking about a case that just came to mind. I represented Jim Gardner in a private lawsuit many years ago when he was running for governor against Jim Hunt, and two individuals who later pled guilty in federal court to misdemeanors, former Supreme Court Justice Phil Carlton and Charles Lane, I believe, who was a partner of Pointer and Spruill, for their engagement in wiretapping then Lieutenant Governor Jim Hunt during the course of his campaign. They had operatives who were literally following the Lieutenant Governor in his car and recording his cell phone conversations. Now, this is back in the early 90s. And that, during the campaign, recording them and providing them to people. And they were also, this is back when you still had phones around your house, the little base phones, the little wireless phones at your house. They were also, the neighbor next door was one of the individuals involved, and she and her boyfriend were recording his base phone calls also. And what I found so interesting about that, talking about what was already set up, we already had laws to prosecute the wrongdoers for that type of political, because the question was about, are people using this in politics and everything else? I can assure you, this is just little North Carolina and a gubernatorial campaign where you had people out there tapping the phones of one of the gubernatorial candidates. Of course, it was against the law for the public. And those people were punished somewhat. They pled guilty to misdemeanors, and then there was a civil action that I represented the Lieutenant Governor on. And consequently, he did lose that race. Now, who knows how much that information had to do with what came out in the vote, but I found it very interesting. It was my first foray into all of those technologies and into all of that law. But just as it is illegal for us to wiretap our neighbors, be peeping toms, do all those kind of things, have surveillance drones, you name it. Think about how much more intrusive it is for somebody to be able to literally know where you are all the time potentially, whether it's through tapping into your locator in your cell phone or following you around the country on license plate readers and having that available all the time, everywhere, and just being out there to potentially be able to be stolen. If somebody can break into the police department computers, we just heard yesterday another big company, a big insurance company, had all of the information on their clients stolen, their social security numbers, all this other kind of data. And then lastly, Sarah, I would just like everybody to hear the Fourth Amendment. Can I just read it? This is what it says. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That's pretty clear. And I think all we're asking for here is our good legislators to pass reasonable laws to guarantee our Fourth Amendment protections against what is apparent to all of us as an intrusive government that has technologies that can take those away from us. That's all we're asking. And I think we have favorable folks here to hear those arguments and to push that forward.
Right, and I would just sort of add to that, you know, when we've introduced these bills in the past, we've always had bipartisan support for them, and this is a time when finding bipartisan support for much of anything is a challenge. So it's an issue where you really can find common ground amongst all parties. And so we are, you know, I think it's a great issue to bring forward right now to build some of that common ground. And we are really hopeful that we will see legislators move forward, and we have a couple of legislators in the room and a couple who stopped by earlier. So we're thankful that legislators are really taking an interest in this. I think I'm going to stop comments there. Does anyone else have any other questions? Did anyone not get their questions asked? Okay, it doesn't look like it. I will open it up to Nate and Senator Goolsby if you have any closing comments you want to make.
I'll just finish. It's always dangerous when you offer a trial lawyer, former politician, the microphone. But no, I just would like to reiterate, you know, how important this is, and that the folks here do listen. I listened when you guys came to me and had important issues. And you know, what gets talked about, what gets pushed forward, what gets continually talked about gets addressed. And this is important stuff. And these technologies are continuing to emerge. And this is our constitutional rights against unreasonable searches and seizures. And it affects every single one of us. Nobody wants to be followed around in their car or on their cell phone or having their information gleaned off of their cell phone all the time without warrants. And that is happening, has the potential to happen, and has happened. And we have got to stand up for this. We've got to put together reasonable laws, you know, willing to start with anything that starts the conversation and then moves it forward. My experience with most law enforcement has been, and I was talking to the lobbyist for the chiefs of police who was in here earlier, is that, you know, as long as we give them rules and say, here's what they are, follow them, they'll do it. But if you don't set up rules, you know, if you don't cage, and I don't mean to refer to law enforcement as a dog, but again, using that analogy, if you don't cage your dog, it runs everywhere in the neighborhood. And once you set the limits up, you can function with inside that, and they will. That's what we've got to do. We've done it in the past, and we need to do it now as these technologies continue to come forward, or it's just going to get worse and worse and worse and more intrusive. And that's just going to be the way to do business. And that's not the way to do business if you live in a constitutional republic that you care about. And I think we all do.
Let me just add very briefly, I think that's all exactly spot on. And the exciting thing for me as somebody who works day in and day out on these privacy issues and these law enforcement surveillance issues is that we're in a moment now where change is actually happening. And you know, as I said, there's been a wave of state legislatures across the country just in the last 2.5 or 3 years that have started updating state laws to reflect what the Fourth Amendment requires. You know, it takes courts a long time to get there, just because of the way litigation works and the slow process of updating constitutional law through the courts. But they're starting to get there too, and so you know, now is the time. And North Carolina is one of the places where I think this can and should happen.
Thank you both for joining us, and thanks to all of you for coming out.